Welcome to Introduction to Probate with Quimbee. I'm your host, Jen Gumbel, an attorney with over 12 years of experience in Minnesota. I'm with the firm Wagner Ayler in Rochester, Minnesota. I'm the host of the podcast Good Legacy, an educator at the website organizedafterlife.com. Today is an overview of a probate process. There are specific areas where I won't be able to go into great detail because of the time. But I hope that will start to get you to become curious and encourage you to take more CLEs down the road. First, let's discuss what probate court is. It's the court that deals with the law and the issues that come up at death and incapacity. This includes legal issues through guardianships or conservatorships. When individuals are unable to make decisions for themselves or pose a danger to themselves through their decision-making power, and the court determines whether or not their own autonomy should be taken away. Probate court also includes appointing guardians for children who are left without parents, or more commonly dealing with assets that are left in minors' names, children who are under 18. But the vast majority of legal issues that probate courts deal with involve the administration of assets that are stuck in a dead person's name. These assets make up the estate. These proceedings are what we're going to talk about today. Keep in mind that probate proceedings are extraordinarily regimented and dependent on the local court requirements. This may be one of the most bureaucratic areas of practice. That means that you need to have an internal methodology in order to keep the matter moving along. This is one of those rare areas of law where you may not get clients calling you on a frequent basis asking what's going on. You also won't get the court necessarily telling you they need certain things or asking what's going on. If you practice in probate, along with other areas of law, you need to have a method to keep this top of mind. Because unlike real estate transactions, litigation, and other legal issues, these might not necessarily scream at you. And that means that these files can inadvertently languish. But when they languish, your clients and other people who are interested in the estate, usually people who are grieving a person close to them, are left wondering what's going on. Maybe second guessing the personal representative, placing strain on relationships. In a lot of ways, you need to be proactive to give these files the attention that they deserve. Your role typically is representing the fiduciary of the estate, and that's the focus that we're going to put on today. Of course, there can be disputes and litigation, and you may decide that you'll also practice and represent heirs or beneficiaries or creditors who have claims and have questions. But the vast majority of representation in probate matters involve representing the fiduciary of the estate. You should be guiding them in avoiding liability. And in many ways, I feel like this is job one when representing a fiduciary. Keep them out of hot water. And like I already talked about, keep the file moving. Your fiduciary, other interested parties, and times the court itself may not be pushing on this matter moving forward. In a lot of ways, it's up to you to get this through efficiently. And you can make all the difference if you're being proactive versus letting these files languish.